Hey, it's time for another exciting video. This time we've got a request. Apparently there's a lot of this happening out there. Barclays Bank Delaware, which is a creditor defense I'm going to talk about. Very similar to Discover and JP Morgan and Citibank and everyone else that's out there. JP Morgan Chase is the real entity there sometimes. But this is going to be another in a long line of creditor defense videos, which I've been getting a lot of requests for again. I tend to go into the debt buyer case because the things that debt buyers do are just so much fun to deal with. But these can be fun too. So what we're going to look at today is the following, and I'll put it up for you. We're going to be looking at a defense of two Barclays cases, two cases from Barclays that were filed by different law firms, but they're very similar in that they lack any real content. Even the name of the person they're suing isn't in the pleadings. You'll find on the membership collection stopper solutions.com, you'll see two answers against Barclays. Those two lawsuits will be defended against. They're two cases I'm currently doing. You'll see two affidavits, which, remember, if you haven't heard me say this before, they are the bedrock of everything you do from A to trial. My last video is from A to C, affidavit to counterclaim. Let's have that one go by. That's a really good one. So we'll be looking quickly at an answer to counterclaim, including the affidavit. But whatever you do, whether it's the beginning, the answer, or the trial, the counter affidavit is your friend, and it is the best bedrock or basis of everything you do. Once you've done the work on that, everything else is easy. Just do it right. I'm going to include with this video discovery against Barclays that you can use, and it's based mostly on securitization, as most creditor defenses are and should be. I'm going to add a counterclaim or two on my membership website, so you'll have full access to all those templates in Word on the membership website to go get them. So let's start. Remember I said we had two lawsuits today? These are two cases that I'm litigating against recently, and I always try to do that with you. When I was in law school, I tried to sign up with as many real attorney professors as I could, because I knew they were in the trenches. Philosophy and background and history, which would be brought to you by any professor, has its place, but I wanted to be an attorney. I didn't want to be a professor or a philosophy major. I wanted to see and mix with the people that I wanted to be. So in this case, I want you to see lawsuits, and I'm actually litigating, plaintiffs I'm actually litigating against, working cases that I'm doing, and you can apply your law and your state statutes. I'm not telling you how to practice in law or life, but these are great templates. So Cindy, let's put up the first complaint, Shazam, and then let's put up the second one, Shazam. So they're both from Barclays Bank Delaware. There's some question as to the name of the entity, and while that doesn't seem significant, it's terribly significant in that you must have standing, and standing is based upon many things that a plaintiff must stand upon. The foundation of which it must be you got the right name that you owe a debt to. So let's look at the first one, and this one is, again, a Barclays Bank, and there are 7 pleadings, and if you look at the pleadings, in fact, let's look at both of them. They're both up there. One only has 4 pleadings, and you'll notice neither one has the name of the defendant. The names are in the caption, okay, but when you're alleging someone owes something, you don't use a caption. You use what's called pleadings within the body of the complaint. They're both titled complaint, as you can see. Sparse, what's a great word? There's a dearth of information here. Somebody's done something to somebody, but we don't know to whom or by whom, because the defendant isn't named. So I used to talk in the early days about a brick. A brick is not a wall, which is a man called Wigmore on Evidence. You'd have this great thing, it's hearsay, so you can't use it. But he'd go, nah, a brick is not a wall. So this is a pretty good brick. You got to name the person you're going after, right? Why wouldn't you? Also, another one of those bricks is where's the contract that both cases allege the defendant, unnamed defendant, breached, the terms and conditions. Again, not only is the defendant not mentioned, the terms and conditions that supposedly were breached of the contract is not attached. Go look for that. Another reason you want that is you want to see the actual plaintiff's name, and we'll get into that a little further in the video, because it'll be right in there. Who are the terms and conditions bargained with? What terms and conditions were breached that you're alleging were violated? All of them? I don't think so. There are no documents attached to either one of these lawsuits proving ownership by Barclays. I know you're looking at this and going, well, they took the loan out and it's not a debt buyer, it's the original creditor. True, but here it comes. You know what I'm saying. If you've watched enough of my videos, this stuff is all securitized. And securitization is a good defense here as to ownership. Philosophically, let's go back to that. If you do sell to a secured trust, if in this case Barclays or Discover or JP Morgan want to sue on it, they have to get the debt back that was sold to the secured trust, because the secured trust gave Barclays or JP Morgan or Citibank, whomever, money for that debt. So if it defaults, there's usually what's called a pooling and service agreement between the parties saying, if this happens, this happens. And in defaults of credit cards, the trust is supposed to assign the debt back. But you're never going to see that. So there's none of those documents attached to the lawsuit. Neither one calls the debt a debt, but rather they call it an account. Is that just an accident? Number one rule, when it comes to money, there are no accidents. When it comes to money, 1A, there are no coincidences. So why in two different law firms, two different cases, are there no, the word debt is not used? We'll talk about that, and if you see my videos, you know what I'm saying. There's no proof either that the defendant owes money under the terms and conditions of the contract the parties supposedly agreed upon. This may sound like the simplest thing ever, but let's put those two contracts up, two complaints up again, if they're not already still up. Shazam. I know this sounds weird, but there's really nothing saying that a named defendant owes money to somebody, Barclays. They say there's a contract. Defendant breached it, did this, didn't do this. But why does someone owe money to this particular plaintiff on an account? It really, if you think about it, read them. You can even look at my show notes, which will be attached to the counter affidavit. And that will also say there's no reason why Barclays is suing the defendant. There really isn't. Think about it. It's really simple, but go ahead and read those complaints. So what is to be made with all this information I just gave you? In fact, before I go further, let me put the 5 things I just said to you that you can use in your defense of a Barclays Bank Delaware case. Shazam. 1 through 5, neither one attaches a contract, neither one mentions the name of the defendant, there are no documents proving ownership, neither one calls the debt a debt, and there's no proof that the defendant owes the money to the plaintiff. What's the proof? And I mean in the pleadings where they say, he did this and he owes us. Look for it. So what's to be done about the big five there? They end up in, you know what I'm about to say, what's the most important document that's based on their documents or lack of documents that we use in the counter affidavit. What is it? Hello? I may have said it before. That's right, you got it again. It's the counter affidavit that we use their documents against them. It's the very bedrock. I got to keep using that word. I'm contractually required to use that word. And it goes along with you when you use the counter affidavit. In this case, any motion they file against you, in your answer. So we've got 2 answers attached to this video at collectionstoppersolutions.com. So you'll also, as I said before, have 2 answers, 2 affidavits. You'll have a discovery, a whole bunch of discovery that are already set to go for your discovery options against Barclays, and also a counterclaim. As I've said before, you want to come out swinging. So you say, here's why, and you identify who it is you have to talk to, usually a debt collection attorney. You identify who is going to settle this case with you. You go, look, here's my answer, here's what it's based upon. And if you feel comfortable and confident, say, you got 7 days to settle this case with me, or I'm going to do a counterclaim based on the above, meaning all the stuff you just told them is BS about their lawsuit. And you'll come to some understanding more times than you will having to file the counterclaim. But have that as your plan B in your pocket. Attached to this video is a counterclaim in Word for you to use and manipulate and use your state law. The reason I give you those 2 complaints I gave you, just to get a flavor of the absolute schlock that you're probably seeing in whatever state you're in, as to the dearth of information. And they get away with this, but not with you, my fine friends. So finally, I want to talk again, as I always do in credited defenses, about securitization. I'm going to put what is securitization, how to get securitized information on your particular case, and I will put it up in the form of my notes. So let's go, Cindy. Start at securitization of the debts and end at securitization must be mentioned in your affidavit and answer and counterclaim. Shazam. So you can read, but I'll briefly go over it and add my 2 cents. You're going to go to a database called Edgar, and it is where you can search for companies or trusts, and you can use a search tool to find filings under the name of an issuer or trust, such as Barclays Bank Delaware. There it is right there. There it is right there. You look for specific forms. I always tell you, go look for the 10K. The 10K is the financial reports each year of each creditor that you're defending against. So for example, you've got a debt that was created in 2017. Go to the 2018 10K financial reports. And what am I telling you to do for that? Just search Alt-F if you're using Word, and you'll find use credit card securitization. You'll find exactly what you want. Okay, so use these databases to find proof of securitization, and then add it onto your answer and your counter affidavit. I'll often add to my counter affidavit the actual financial information just to support and buttress my counter affidavit. You'll also look at prospectuses and asset-backed securities. So Cindy, take that down if you didn't already. Here's the impact of securitization on your case. And this is important. I'm going to read it. I hope I don't bore you, but it's simple. When debts or loans or credit card balances are securitized, they're pulled together and sold to a special purpose vehicle, SPV, which then issues securities backed by the debt. So it's dropped into a secure trust that has been invested in by bondholders. The debts don't disappear, but hold on. Instead, they are transformed into securities that can be bought and sold by investors. So think about this. if the debt has been transformed, and if you just think of the movie Transformer, it's a school bus turns into a monster. Well, it's not a school bus anymore, and it is not going to be going back to anywhere as a monster, and it doesn't get transformed back. So once it's transformed, it is now something that philosophically, logically, 2 + 2 = 4, can no longer be sued upon because somebody else securitized it. It is a security. That's what securitization is. It's a fancy word. I've thrown it around. Hey, what is that? It's where a debt has been turned into something else. So after the debts are securitized, the original debts continue to exist, but they're now owned by a different entity, and they are debts in the sense that they represent money borrowed by borrowers, but owned by somebody else. So in order, just like a debt buyer case, in order for the plaintiff suing you, they must have a perfect chain of title from who? The people that bought the debt and turned them into securities. They must assign it back. And without that, you can't be sued. It's simple, but it's, you're having a hard time with judges that what is securitization? You just got to hang in there and have your proof. Proof fills all voids. So if you've got a void between your position and the judge's understanding, talk his language. Use the thing that his commodity is, proof. That's what laws and burden of proof, everything is based upon what can you prove. So just like the plaintiff can't just say you owe something based upon a breach of terms and conditions that you kind of don't have attached to the lawsuit. When you have your defense, because as I said, a well-fulfilled and pled counter affidavit travels with you, it's got the proof, right? So this information about securitization is that void will be filled. So make the judge understand what's going on. Now, lastly, after securitization, the servicing of the debts occurs by usually the original creditor. So the original creditor sells the debt and he keeps what's called the servicing right. So you'll send a check to, or however you pay, to Barclays Bank. They'll send the money to the bondholders that paid, invested in this securitized trust, minus their fee for collecting the debt. They're servicing the debt, right? But they're debt collectors. So anytime you get sued on a securitized debt, it's a third party. And unless they provide you proof of an assignment from the securitized trust of the debt, no, the security, so you're never going to see it. But you will see, as I said before, the word account used. Because really, that's all that's left. An accounting rather than a debt. The debt is already changed, transformed, gone. And unless there's an assignment, and if you look at my discovery that I'm giving you, it asks for those assignments from the trust back to the creditor who's suing you. Because otherwise, they have no standing to sue you. Keep that in mind. It all goes in your counter affidavits. Look at the 2 counter affidavits I gave you. And then your securitization theory, not theory, proof, will be mentioned in your affidavit and answer and counterclaim. And that's your defense to a Barclays Bank Delaware lawsuit. In my discovery, you'll see that it's on collectionstoppersolutions.com, mentions those assignments, the name. What's the name of the company? It might be Barclays Delaware Bank, but do a quick search. You can also see from one of my affidavits and one of my answers that I found who under the 10K that I was just talking about in Edgar, the name of the company that some of these Barclays debts were transferred to, Bedrock, believe it or not. That's that's in my head. It's the name of the trust. So go get them. This is the Barclays Bank Debt Collection Protection Defense. Hope it works for you. And like, love, and subscribe. Go do your own thing. Use your own state laws. But go get them. You got the goods now. Just develop this with your state laws, theories, and facts. And what else are we using? Hello? That's right. Their documents, or in this case, their lack of documents against you. Good luck.